All right, good afternoon, everyone. I am so excited to see such a packed house here today. Thank you so much for being here. I hope you're enjoying your Chipotle. I know our finalists and our judges. Certainly, I really appreciate you all being here to watch a live negotiation in just a couple of moments. This is the final round of our Halloum Business Negotiation Competition, which is just a really exciting collaboration that brings in students from the business school here at Berkeley Haas, as well as JD and LLM students here at Berkeley Law. They are paired together based on their background in either law or business to negotiate a series of transactions that have ultimately led us to the deal you're going to see today. Or maybe they won't reach a deal. Who knows? We'll see. My name is Natalie Winters. I have the pleasure of being the Director of Advocacy Competitions here at Berkeley Law. I want to make sure and thank a couple people, and then I'll make sure we get started because I know we're on a tight timeline with the lunch hour and classes starting soon. I want to extend a special thanks to the competition's founder, Joseph Halloum. He unfortunately couldn't be here today because he is, I think, in Dubai negotiating a deal right now. But he worked very closely with our team in developing the fact pattern that you had in this year's tournament. I also want to make sure and recognize the fantastic team of students and staff that I had the pleasure to work with, as they really ultimately did a lot of the work behind the scenes to make this tournament possible. They're seated in the back. Their names are Evie Nevin, Ivan Lazarenko, Yoon Yu, and Alice Shu. Please give them a round of applause. I also want to make sure and recognize the finalists who are seated in front of you today. Their bios, as well as our final round judges' bios, are in your program. Representing Party Vroom, we have Shan Vijay and Tiana Wang. And representing Party TeleTogether, we have Ron Jiang and Andrew Park. Our judges, there's additional information about them in your program. I wish I could have more time to thank everyone and tell you about all of the amazing things we have coming up later on this year in competitions, but I know you're not here to hear me talk. So let's get to the negotiation. Over the next 40 minutes, you're going to see these two teams negotiate with each other, and then you'll have a chance to hear from each of them for about 5 minutes about how they think it went. They'll actually do like a self-analysis in front of our judges. And at the very end of today's final round, you will have a chance to see us announce the winner of the tournament. So thank you for being here. And without further ado, finalists, when you are ready, the floor is yours to begin your negotiation. Good luck.
All right, well, hello. I'm Andrew. This is my colleague, Ron. I'm here on behalf of TeleTogether. First off, thanks for coming to meet with us. We're really optimistic about our previous negotiations, and I understand that changes in the market and changes in circumstance have kind of caused us to come back to renegotiate, but we're still very optimistic that we can hammer out a deal together. Yeah.
That sounds great. My name is Tiana, and this is my partner, Shan. And similarly, we feel great about what we've had so far, and we're excited to move forward. So just to clarify, the 4 terms that we're here to discuss today are exclusivity, non-solicit, indemnification, termination fee and reverse termination fee, and the timing of that, and the purchase price. Do those sound good to you?
Yep, we're tracking those same 4 deal points, and we're happy to proceed in any order that you guys would like to.
Okay, excellent. Do you mind if I write on the whiteboard just to keep things?
Absolutely not.
Okay, thanks so much. So in terms of our priorities, we would really like a non-solicit exclusivity provision, and we understand that might be a sticking point, so we're very happy to talk about that. And that's kind of our priority as far as things go. We'd also love to talk about indemnification and what that looks like for us, and the termination fee and reverse termination fee, and of course the purchase price is important.
Yeah, we're fine with diving in that order as well. So just starting with exclusivity, just I guess to begin with, we're definitely open to a non-solicitation clause and being exclusive to Vroom. However, I would like to caveat that with our appetite for exclusivity is sort of informed by the valuation of the deal. So we're happy to start with the assumption that we'll be exclusive to Vroom, but I guess we just need to proceed with the mutual understanding that does affect how we view the tolerance of other terms. And I think one thing, and so yeah, we could proceed with the assumption that we are exclusive. Another thing that I kind of wanted to bring up, if we do have to kind of come back to this exclusivity portion, we were also thinking that matching rights is one way we could sort of expand the landing zone. Matching rights, we see it as a way where we would still be completely exclusive to Vroom, but it would just be subject to Pan's willingness to pay or match. But yeah, we're happy to proceed under the assumption that we're exclusive.
Okay.
Thank you.
That's great. Thank you so much.
So then you mentioned that for the non-solicitation exclusivity provision, you would want to be informed by the purchase price as well. If that seems relevant to you, we can dive into that a little bit now.
Yeah, absolutely. Absolutely. I think Ron has some good ideas about how, or methods of valuation. If you are interested, she could kind of outline how we value ourselves, and we'd also be very interested in seeing how you guys value us and see, how we can resolve that discrepancy.
That sounds great. Please, the floor is yours.
Yeah, I think for us, we are like still a startup that growing really fast. So for the valuation, also like the purchase price, there are like several key factors we will really want to be included. That's like from our side, we have this valuable IP, like our unique tag, which brings a good like intangible asset to us. And also we have a really strong user base and business models, which gives us a lot of growth potential, both on like the future revenue streams and also on the reputation we have in the market. So we really want to have those included. And also like, since this is an acquisition deal, I think it's also like creating a lot of synergy on the Vroom side. So as you're acquiring like 60%, like the rest of 60% equity, which is giving you the full control premium of using our technology in your products. And then also we want that control premium be included in our valuation. And also finally, we think this acquisition can give you a really strong market position. And as we also getting offer from Google Plex, who is like a strong competitor in the video conference space, we are talking to you because we think this deal can give you a really good winning point on the competitive landscape. So that side, we are thinking use a model that's based on the revenue multipliers. And then in terms of the multipliers, we are looking at the comparable companies in the industry and the past deals. Yeah, if you are good with this kind of model, we can dive into the numbers later. Yeah.
Oh, yeah, absolutely. Revenue multiplier model, I think we're very happy with proceeding under that as well. So if you want to share some numbers that you have on top of mind, we can definitely like dive into that right now.
Yeah, do you mind if I do the calculation on the whiteboard?
Yeah, sure.
Thank you. Yeah, just to show that we used our 2020 revenue we already got, which is 15.8 million, and then we applied a growth rate to project our 2021 revenue. And then we used a multiplier of 16x, which gives us a total valuation around 216 million. For the revenue growth, we already considered the current market situation as a lot of certainty in the post-pandemic situation. So we used like average growth, like a midpoint before COVID and after COVID. And then also for the multipliers, as I mentioned, it's based on the past deals in the online, social, and media, video conferencing market. We'd love to hear your thoughts on those numbers.
Sure.
Yeah.
No, thank you so much for laying it all out. This is very helpful. I think first off, maybe something I'd just like to ask is the 15.8 million projected revenue. I believe that was like a projection before the changes in the market scenario have come into place. So we'd be a little bit hesitant on starting with that as the projected revenue first and foremost. And secondly, to then apply a further growth rate on top of that seems a little preemptive, given the sort of nature of things that have brought us back to the table, right? And of course, once we have that aligned, we'd love to dive a little deeper into the multiplier of 14 as well that you've chosen. Just from our analysis of competitors in the market, we've seen about 3x being the multiplier for subscription entertainment sector. Of course, given the success that we've both mutually enjoyed and the strength of the IP and Pan's belief in Yamada and Jiang as well, we'd be happy to go, of course, above that and give a premium on the multiplier. But we do also feel that 14 is a very strong premium, especially given the changes that have brought us here and the ongoing market outlook.
Yeah, I definitely understand your concerns of the market uncertainty and also like some of the deals you mentioned in the past. In terms of the revenue, it's our 2020 revenue. It's like we're wrapping up our 2020 financial year, so the revenue is like will not be changed a lot, although it's like a projection, but it's like reflecting the actual revenue. And then in terms of the growth, I think we had like more like aggressive growth projections during the COVID period as we see a bloom that time, but we already lowered down the growth rate to 20% from 25%. I think that kind of addressed your concerns. And then finally, in terms of the multipliers, I think some of the comparable company you mentioned is more like only gives a subscription model, but we already have a really strong platforms that also have like different pricing models to generate revenue from our users. And then the past deals we're looking at is platforms like Discord, Spotify, or Roku and Roblox. They actually have multipliers up to like 40 or like 24x. So I think giving 14% is like pretty conservative for our current situation.
Thank you. I hear where you're coming from. I would just maybe point out that some of these competitors that you mentioned are in a slightly different space where they offer entire fully fledged social media capabilities as well. And social media multipliers do tend to be a little bit more inflated as compared to subscription and event and entertainment spaces. If we were to proceed with the assumption that this 15.8 million is the revenue that you will be hitting for this financial year, that is something that we can go ahead and proceed with. And just to clarify, you said 14%, but I'm assuming you meant 14x on the multiplier, right?
40x, yeah.
Perfect, just to make sure. All right, I hear where you're coming from, and I can see where you're sort of leaning towards it. To be very realistic, we were looking at more something like a 6 times multiplier, which we felt is fair in terms of the premium we want to offer you, given your strong IP and the fact that we have very strong faith in Yamada and Jiang's capability to sort of navigate these waters. 14 does seem to be very much on the higher side, and that's already, again, accounting for the fact that we're assuming that 15.8 is the real revenue that you would be generating in 2020. And the growth rate is another point that we might have to come back on. But now that we have our sort of initial points out there, would you prefer to like keep talking about these points, or would you like to sort of air out some of the other issues and understand where we're each coming from?
Just so I can interject real quick for clarity, where we're at on price point right now is we're agreeing to use the 15.8 mil as like the revenue value. The only difference in our valuation right now is the revenue multiplier. And so is that where our discrepancy is just in that revenue multiplier?
Yes, and the growth rate.
Okay, and the growth
and
rate.
Again, assuming that the 15.8 is the actual revenue and not just a projection.
Okay, I think the 6x, 14x, and the growth rate discrepancy can definitely be overcome. We'd be happy to move on to some of the other terms and circle back and see. I mean, we hear your concerns about being cautious about overinflating the price, and after we talk through the other 3 terms, maybe we'll take a 5-minute break, reassess, and come back in with another package, see if we can resolve that gap.
That sounds great to us. So on the topic of indemnification, is it okay if we jump into that one?
Absolutely.
Okay, sounds great. So we've already agreed that money will be held in escrow for 5 years, at which point the remainder will be released to TeleTogether shareholders. And now what we're negotiating is the minimum amount to be withheld. So we're really hoping for 10% on this one due to the copyright issues. So as I'm sure you're aware, IP is the most important asset that a tech company can have. And just kind of given the claims and who is behind the claims, we're really hoping that for this is really to also benefit you guys, that we can kind of put more money into that escrow account so we can really get the best legal representation possible to fight on our behalf for this.
Yeah, so up front, 10% does not seem too palatable to us. We're honestly thinking along the lines more towards 3%. But I think that my hunch is that that gap in percentage may be from a lack of shared understanding with regards to the legal risk. So could I just clarify how you guys view like what the legal threat is that Gulu is posing? Because I know like in terms of litigation threat, it can range from anything from like a Mickey Mouse settlement amount to like an existential threat to the company. So could you guys like clarify where on that scale of threat you guys see this Gulu litigation at?
Yeah, right. So as you pointed out, we don't have a lot of information on the facts. Yamada and Jane have made a public statement that TeleTogether's technology and business model are deliberately designed to avoid those potential copyright issues, which is great. But we're not the judge and the jury over here. And I think that when it comes to something of this scale, it's really about like the legal representation. You have the people representing you. You're going up against Gulu's lawyers, which are really excellent. So that's why we would prefer to put a bit more money there, just for added security.
Okay, so I do think that assessing the legal threat and the risk is important to kind of inform what percentage and what level of indemnification we agree on. Me and Ron, for this particular Gulu suit, we actually see the litigation threat as relatively low. We're not necessarily concerned about the merits of the claim. I know you mentioned that specifically because this is a copyright issue, it's a little bit of a thorn to you guys. But as you also mentioned, Jane and Yamada have made public statements saying that our business model and IP are specifically designed to handle claims like this. So we're very confident that the litigation would not have a materially adverse effect. And so our remaining concern and the way that we perceive the litigation threat is we're more focused on or more worried about just the administrative costs that it would take to sort of repel this threat. But given that the litigation will not result in anything materially adverse, we're anticipating that those administrative costs used to sort of fight against this litigation would be far below the escrow account amount, even at a low percentage. And I think part of the agreement stated that after 5 years of being withheld in escrow, the excess would be transferred over to shareholders. And when me and Ron looked at this, we didn't necessarily think it was the best business decision to allow excess to go directly back to the shareholders.
Yeah, I can chime in here. Like we think like having a lot of money in our escrow account is not good for like as a business perspective, both like not good for the shareholder and also for business growth. Like having those amount in our account that only paying like the minimum interest of the market is definitely worse than like investing those money in R&D or like even pay our dividend to shareholders, including Vroom. So that's why we were proposing like giving like our like legal risk is pretty low as we assessed, and then we just want to limit the amount in the escrow account, like drop to 3%, as Andrew mentioned.
So the bottom line is basically at a high percentage, this escrow account is going to balloon, right? When we have the litigation will result in most likely an expense that's far less than that escrow amount. What Ran is essentially saying is, with that excess funds, it'd be it'd be a wiser decision to reinvest in the company given our stage and our current projects, rather than just hand out a dividend to shareholders at such an early stage. And because of that, we think a lower escrow account percentage of the purchase price is kind of the more cautious and business safe route to go.
Yeah, thank you so much for that context. I know you mentioned that it's not a materially adverse threat. So what we're worried about here is kind of the scope of this threat. Like we don't want sharks in the water smelling blood. Like Google brings this, but then what if like other really big companies bring further copyright litigation lawsuits? That could cause a lot of damage in the long run. And copyright issues are something that we take pretty seriously, just given the history of what happened. I mean, like in 2000, I know this is a while ago, but like MP3.com was found to have infringed 4,700 records at $2,500 per infringement, $25,000 per infringement, and then they ended up selling for $58 million. But that's like a big chunk of change. And companies like Napster kind of were just devastated by the copyright claim. So we want to avoid that if possible. And it's really great that you give us that context. Maybe we could consider even talking about potentially a way to expand the pie. So like when preparing an escrow agreement, there is a bit of leeway to define the escrow triggering event. If outside counsel or, I don't know, someone were to find that there were no materially adverse threats, then, maybe that could be the condition. Like if there is no materially adverse effect, then we don't have to go with as high a number as 10%. But if there is something, then we should be able to still have a higher number that satisfies our need for security.
So I feel like I think we still don't quite see eye to eye in terms of what the threat that this litigation poses. I know that I hear the concerns about the copyright risks or copyright issues. I think that's something that we feel very confident about. But to sort of address that issue, and I know we're talking about expanding the pie, I think one thing that we would feel comfortable about is providing a representation or a warranty with regards to the state of our IP and our business model as being specifically designed to handle claims like this. If we add this representation and warranty, and these copyright claims are legitimate, then you guys could potentially collect damages for breach of warranty, which would sort of make up that difference in the percentage that goes into the escrow account. And so we see that representation and warranty as sort of a means for you guys to still insulate PAN from risk, but only collect the funds when needed, when our warranty is breached. And I guess, does that make sense to you guys?
Yeah, I hear that. We think that representations and warranties are definitely very important. Maybe we could even consider representation and warranty insurance. But for the sake of this negotiation and what we're bringing back to the clients, unfortunately, the only thing that the client is kind of looking for at this point is like that number on the escrow account. So if it sounds like there's kind of a big discrepancy here, maybe we can move on to the reverse termination fee and termination fee and see if there's any wiggle room there.
And just to clarify, we're at 3% and 10%?
Yes, 3%,
okay.
10%.
Oh, nice,
yeah,
perfect.
So in terms of the termination fee and reverse termination fee, apart from the fee percentages themselves, we were also we specifically also want to drill down on what would be the triggering point of these. So in the case of reverse termination fee that Vroom would be paying to TeleTogether, that would be in case we terminate the agreement due to, for example, issues getting antitrust approval or approval from TeleTogether shareholders. But in case of TeleTogether being the one to terminate the agreement for whatever reason, we were hoping to have that at termination point is when the termination fee would trigger. Is that something that makes sense to you? Are you
Is at termination point at the close of another deal, just to clarify?
At the moment that you terminate the deal that we're hammering out right here, not at the point when you're closing the deal with another party.
I see. And would we, so I'm trying to understand how this would work with exclusivity. So when you're referring to the timing of at termination point, that's when we notify you that we don't want this deal to happen?
Right, before you have ideally signed or closed a deal with another party. Before signing or closing, yes.
Okay, so I think just off the bat, agreeing to a termination fee prior to signing and just based off notice is kind of an unacceptable risk to us. Okay. I know, like a termination fee, even at a termination fee of, let's say 5% and a purchase price of, just for the sake of easy math, 60 mil, that's a 3 mil termination fee. If you look at our current financial statements, we only have about $1 million in cash assets and cash equivalents. So having that termination fee trigger prior to us being able to secure investment from another company or another competitor, our ability to pay is seriously jeopardized. And at that point, it becomes a real risk that we want to avoid. We don't want to take on existential risk if avoidable. One thing we would be open to is for that termination fee to kick in prior to closing, but after signing, because there still is deal certainty risk, but at that point, we feel that would be the happy medium of when this termination fee would trigger. I understand that on closing, that's kind of unfair to you guys, as it sort of leaves you out of the loop and doesn't give you time to re-strategize how to proceed without TeleTogether. But I do think that prior to closing, but once we sign another agreement, that could potentially be a happy medium for the trigger.
Oh, thank you for bringing up your concerns. I totally understand that you don't want to open yourself up to a certain amount of risk beyond what's palatable given TeleTogether's current financial situation. But at the same time, PAN would like deal certainty, and in good faith, we would of course hope that the exclusivity is not breached and there is no need for a reverse termination fee. Given the fact that, as you expressed, right, upon signing, if we were to process a termination fee that feels a little bit more balanced to you, we're happy to consider that under the provision that the reverse termination fee then be marginally lower than the termination fee. And you mentioned in your quick back of the envelope math that $3 million, for example, might be too much if we take 5% of 60 million, right? We're happy to go with a low percentage. We're happy to go with something like, for example, say 1% as a reverse termination fee and 2% as a termination fee, giving TeleTogether the added advantage of only having to pay that termination fee upon signing, whereas from Vroom's perspective, we would have to pay it the moment we're not able to close a deal because of antitrust or shareholder approval. I think that fairly balanced out the risk where we would be open to paying it almost immediately. You have a little bit more time to find a deal, and then these percentages are a little bit more reasonable, not putting undue pressure on your financials, if I've understood your concerns appropriately.
Yeah, I mean, I think you absolutely do, and I do think establishing a low percentage for the termination fee and reverse termination fee absolutely addresses that. I think we're happy to hold at those values for now. If you wanted to take that 5-minute break and allow Ron and I to discuss, and hopefully we can come back in with a complete package that we could discuss that addresses both of our concerns.
That sounds great. Yeah, I think it's a perfect time to break. I think we've understood each other's interests a little bit better, and it'd be a good time to collaborate and come back.
Sounds good. Sounds good.
See you guys in 5.
Audience members, stay in your seats. This is normal. This is not a drill. Our teams have the option of calling a 5-minute break if they want to talk to each other in private, which means not around us. So they are going to break, did I hear 5 minutes? Is that the plan? For 5 minutes. We will see them back in 5. For now, feel free to talk amongst yourselves, munch on crunchy, loud chips, and open your soda cans. And we will resume when they are back in the next 4 minutes. Thanks. All right, folks, let's bring ourselves back to competition mode. Please stop your side conversations, close up your chip bags, but if you want to keep munching on a burrito, knock yourself out. We're going to get started with our negotiation momentarily.
All right, we good to go again?
Yeah, let's go.
Yes.
Let's go.
Awesome, awesome. So me and Ron, we've heard your concerns and we've kind of assessed where we are in terms of value. And I think we do have a full package if you guys just want to see up front like what numbers we're thinking, and we're happy to dive in one by one and see what's there's still left to resolve. But in terms of exclusivity, I think we're totally fine continuing under the assumption that we're exclusive. Indemnification, I understand your concerns about the copyright claims. I think that I would like to emphasize that when that indemnification provision kicks in and the escrow account is dispersed to shareholders, at that point, it is in our mutual interest to make the correct business decision because at that point, you guys will own TeleTogether. But we are happy to bump up the indemnification to be 5% of the purchase price. The reverse termination and termination fee, I think, I do think that that's very reasonable. We appreciate you understanding like the risk that a termination fee would pose to a company in our stage, and keeping those percentages low is something, if for us to keep ours low, we're happy to have yours low as well. In terms of purchase price, we hear your concerns about overvaluation and the uncertainty around calculating an appropriate growth rate at the current time. So one thing that I think me and Ron have agreed on, just kind of Xing out the growth rate in the calculation completely and going down to a 10x multiplier. Is there any particular point you guys want to dive into first?
Sure, no. Thank you for laying this out. This helps. I think something that we didn't touch upon, and we'd love to hear your thoughts, is you mentioned that there has been some interest from Googleplex. We'd love to understand from your perspective, is there anything other than acquisition price that you're interested in terms of like a strategic partnership or value alignment? And the reason I ask is because, again, we both had immense success with our partnership so far. And we just wanted to make sure that our values are still aligned in terms of fast innovation, ensuring that Yamada and Jiang retain control of the operation, and providing the highest quality of user experience. I think these are 3 key values that have brought us so far in our journey of mutual success. We just want to make sure that there are still these same benefits on both sides before we drill a little bit deeper on the purchase price.
Yeah, absolutely. I think from the get-go, we've seen Pan and Vroom as the ideal bidder, and I don't think that's changed at all. We'll receive competing bids, of course. I mean, it's our fiduciary obligation to sort of entertain and see what value we can get. But throughout this entire process, Vroom has absolutely been the ideal bidder, a large part because of the synergies that Ron has kind of touched upon. But that hasn't changed for us.
Yeah, just add to that, we definitely already had our partnership with you for a while, and then we do think this is the best culture fit in terms of having you as our acquisitors instead of Googleplex. And then we're looking for like a high valuation, just want to reflect our business model potential and also like the intangible assets like the IP and the technology we have, as I mentioned. Yeah, and also we are using this fund to like invest in our R&D and like just like everything on the business growth. So definitely we see like a good opportunity for both us in terms of these deals. Yeah.
Yeah, well, thank you so much for sharing that. And I'm really happy that we're able to reach an agreement on some terms. However, the indemnification is a bit, we're really happy and very appreciative that you're willing to like go down, go up. But 5% unfortunately is a little low for us. We would really like to see 6% if that's possible.
What's your opinion on like the valuation part or the other terms?
Sure. So we appreciate you coming down from 14x to 10x, and of course the growth rate given these markets. Happy we can see eye to eye there. I'd like to propose a slight modification to this with what's probably called an earnout clause. So we totally understand that there is great potential in the IP, but again, given the current market situation, we want to sort of understand how we can address both sides of that. We'd like to propose a 7x multiplier on top of 15.8. And in case in 2021, TeleTogether is able to hit 20% growth, we'll factor that in and provide an additional cash infusion as part of that earnout. So then the offer that we're basically putting on the table would be 6% for the escrow, and then a purchase price of 7x plus the earnout. And I believe this way we can, both our parties can be very satisfied, both our clients can continue to see the success that they've had. And just one quick caveat I'd like to point out is that upon the earnout being hit, we'd like the same percentage of indemnification to go into the escrow as well. And again, just to reiterate, this is just to protect our mutual interests. If these copyright claims, for whatever fluke, bad luck, go through, it would be a disaster for both our parties. Yamada and Jane would lose their beautiful brainchild. It would be a huge fiduciary loss for both our parties. Just to protect that, ensure that we have enough financial resources to fight that legal battle to what should be its natural conclusion. That's where we're coming from with that.
Yeah, thanks for proposing willing to go up to like 7x plus our earn-out structure. I think the earn-out is not necessary here because we already have an escrow account at 6%, and then the earn-out just hold more investment upfront for us.
I'm sorry, if I could just clarify, the earn-out would not be going directly into the escrow. The earn-out would be an additional sort of cash infusion as like an additional on top of the valuation.
Yeah,
so the earn-out would basically increase the valuation that we're looking at, assuming that this 20% growth, or again, we can talk about that particular number, if that sort of benchmark or milestone is hit. And the 6% share of that would go into the escrow, not the entire amount. So we want to maintain that 6% is still 6% even once the earn-out is met. But we don't want to funnel that entire money in there. Naturally, we want to balance the business growth and securing against the copyright claims.
Yeah, definitely. I understand the earn-out structure. My concern is like mainly two areas. The first, like both earn-out and the escrow account, we see that's like a risk mitigation tools for you. And then since you still like trying to get 6% for the escrow account, and that's why like I'm saying like we don't have like double insurance on the risk part. And then another concern would be like the earn-out will based on like certain strategic certain milestones we reached, and then we need a more like further discussion on like in terms of what's the milestone we're thinking or what's the benchmark. I think that's just adding complexity to the current deal to our table. So yeah, I think we are not willing to accept like our earn-out structure. And then yeah, I think also like trying to understand your concerns behind this, like more like a financial stress for you to like not paying the whole amount up front or like just for risk mitigation.
Sure, thank you for bringing that up. We see it as basically a way to make sure that the valuation is not overinflated, so you can still continue to grow sustainably without undue pressure to meet targets. At the same time, this gives you an opportunity for Yamada and Jane to meet the targets that they're setting for themselves and hence reap a bigger reward. It's intended just as sort of an incentive to make sure that we're not underestimating their ability to perform, but at the same time, we have responsibility to PAN and the board to ensure that we're not overvaluing the IP given the sort of current situation. I believe it was, what, a 20% increase in user churn, 15% decrease in active watch time. These are worrying metrics, and while we have full faith that Yamada and Jane will come up with creative ways to address this, we want to make sure we factor that into any valuation that we do. But if you're not happy with earnout, we're happy to take that off the table, but we'd love to hear any other offer that you might have that's more acceptable to your clients.
Yeah, I mean, I was just going to suggest, for those reasons, I mean, we appreciate the attempt to kind of put a new shape to this deal so that might be more agreeable to us. But I think we are focused on cash infusion up front, and an earnout sort of delays receipt of that cash. And so it's not as favorable to us. We are happy to, I think, lower our multiplier and just forego the earnout provision. So instead of going 10x, maybe we go at 8x with no growth percentage factored in, or no earnout provision factored in.
All right, would you be willing to do, in that case, 8x, but then 6.5 on the indemnification? If so, that's something that we could happily take back to our clients.
So I think, so the 8x offer was made, so I should have made this clear from the get-go, with the assumption that 6x is fine. I was 6% for the indemnification purchase price cap being implemented. I think we're fine with a package of 6% purchase price and an 8x valuation. Ron, if you want to chime in on the valuation, are you happy with that 8x valuation?
No.
Yeah?
Mm-hmm. You mentioned 6% indemnification and 8x valuation.
Yep.
Let's see.
Because I think in response to our 5%, you guys were looking for 6%. We're happy to move up to 6% upon removal of that earnout provision, but we understand that, and replacing that earnout provision with a lower lower multiplier than previously discussed.
Yeah, also like if your concerns are more about the legal risk side, would you be willing to like stay like 6.5% identification but bump up the valuation a little bit to like 10x, like still stay the 10x?
I think 10x might be a little bit too much, but I appreciate you reaching out. Again, what we would like to achieve with this is make sure there's enough financial reserves for that legal battle. So we're happy to go up to 6.5 and then take the valuation up to 8.5x. If that satisfies your clients.
Are you happy with the value? I'm happy with the indemnification provision.
I think we're good.
All right, yeah, I mean, I'm happy with that.
Well,
Amazing.
great. So let's just note down the finals, and looks like perhaps we might have a deal. So 6.5%. And then just stays the same. The timing is, yes, for the timing of the at signing.
No, that's signing.
And purchase price was 8.5. All right. Well, it's been a pleasure.
Amazing. Thank you so much.
Thank you so much.
With a minute 30 to go on the clock, a deal is reached. Everyone, round of applause for our finalists. Okay, so here's what happens next. Both teams are going to leave the room. I'm going to leave it to y'all to negotiate in the next 30 seconds who's going to present first. Each team is going to have 3 minutes to prepare their post-negotiation analysis. That's where they tell us what they think worked, maybe what they would have done differently, what they think maybe blew up in their face today. I don't know. We'll see what they think. They're going to head out there, and one of them is going to have 3 minutes to prepare. Then one team will come in and do a 5-minute post-negotiation analysis. And then we'll bring the other team in here, and we will hear from the second team. So teams, do we know who's presenting first?
Rock, paper, scissors.
Rock, paper, scissors. Sounds good. They'll duke it out by hand, and then we'll get started with analysis in just a minute.
Right, we'll go first. Sounds great.
All right, we'll head out.
All right, please give your attention to our first team who's about to start their post-negotiation analysis.
All right, so coming into this negotiation, we really wanted to keep our clients' priorities in mind. For our clients, the most important thing was the client required an exclusivity non-solicit clause. And we were really willing to fight on that, but the other team was very was very easy to work with there. So we were just delighted to have that done off the bat. The next thing we wanted to work on for our client was indemnification and escrow. The client wanted 10% to 5%. We settled on 6.5%, which we felt was reasonable within our client's range. And given the other team's articulation of their needs to use those funds for other purposes like R&D, we felt that we were pretty compromising and we're satisfied with what we ended up having. For the reverse termination fee, so we ended up settling on, I believe, 2% for the termination fee and 1% for the reverse termination fee. And that was great for our client. The client was open to 1% to 3.5%. For the reverse termination fee and a termination fee of 1% to 3.5%, with a higher termination fee than the reverse termination fee if the timing is a bit later. So what we decided on for the timing was at time of signing, not time. So it was acceptable to our client. For the purchase price, there was a lot of negotiation on that, as you probably saw. So we kind of structured our offer depending on the seriousness of the offer from Googleplex. And we were willing to go from 6 multiplier to 12 multiplier. We ended up settling on an 8.5 multiplier, which we were satisfied with, and no gross rate. And then in terms of overall strategy, so we had 2 main issues that we want to talk about. One was, obviously it's a Googleplex offer. We wanted more details on that. We wanted to know how serious it was because we felt that we had a lot of leverage in terms of how much Yamada and Jiang wanted autonomy. And we felt that with Googleplex, they were going to lose autonomy. And we really wanted to learn more about their thought process behind the offer. And then the other thing was the copyright litigation, which, as I brought up, copyright is a really serious thing, especially for this startup that's a tech startup. And we wanted to make sure that we kind of eradicated the threat, so to say, upfront, so that later on it would not pose further issues if other, like Netflix and Amazon wanted to pile on and just drags this out for a long period of time. That's why we were really pushing for that indemnification. Yeah, and then in terms of what Shan did, I felt that he did a phenomenal job with talking about the earnout. I think that was a great way of re-anchoring when we weren't completely satisfied with their package after coming in after the break. And I felt that helped us get a more favorable package for a client. The other thing was going back to the Googleplex issue. So we know that usually we want to start from a lower price as buyers, but just given how much uncertainty there was, we didn't want to come in too low and offend them and then just have the negotiations go poorly from there.
In terms of, I think, what Tiana did really well, again, starting off with the whiteboard was very helpful in terms of anchoring it. There was a lot of numbers going around. It was helpful to look at that and have a reference point. The other thing, I think she did a really good job of making our priorities very clear, providing a structure for the rest of the conversation to follow, so there was no confusion about what we were talking about. And she also did a very good job of making sure our priorities were clear. Specifically with regard to exclusivity, I think it was really good to have that sort of tentative, yes, we're on the same page about that at the get-go, because a 40-minute time was very short, so this gave us enough time to focus on the nitty-gritties of other issues that came up. In terms of things that I think we could have improved on, I think while we started strong with the whiteboard, it got a little confusing towards the end, as I think maybe a little bit of time pressure and different parties coming together, which towards the end became a little bit confusing. Other things that I think we could have done was at the very beginning of the conversation, get deeper into questions about why, understanding their interests deeper. We tried to do that a little bit more after we came back from the break, but I think it was because there were so many factors going on, we lost sight of what was there and got tangled up in the weeds a little bit. But I'm glad we tried to recover that a little bit and were able to do enough to come back to a final agreement.
Yes, just adding on to what Shan said, I think that the whiteboard definitely could have been handled a little bit better, especially towards the end. And I think another thing we could have done is potentially push more on the timing of the termination fee and reverse termination fee when those are the timing of when TeleTogether pays, but given how tight the time was, we didn't want to open that up and then have that be a whole nother thing. So we were satisfied with at signing, so that's what we ended up sticking with.
And yeah, and the last remark, this is all within what our client wanted. So if our client is happy, we're happy as well. So that was our guiding principle here.
Yes, happy to be employed. Yeah.
That's our time. Thank you.
All right. Thank you.
Thank you. Hello. We're ready to start our post-negotiation analysis when you guys are. So I think we'll probably just talk about this in the same order that the deal terms sort of played themselves out. So the first thing that was brought up was the exclusivity provision. We actually anticipated that this might be broached first, just given the market conditions and given the competitors giving us offers. We anticipated that exclusivity would be important to Vroom. So we sort of were ready to structure our tolerance of the other terms based off the assumption of exclusivity. So I think that helped us get off to like a pretty good start, as well as starting on the right foot with a term in hand that we can agree upon. And then we moved on to purchase price, where I think Ron put in a lot of work in creating like very grounded valuations at different benchmarks and different points. If you want to kind of talk more about that.
Yeah, in terms of the purchase price, I know there are some more like other models that less favorable to us, like the EBITDA multiply models, and also like there's like an asset-based valuation. So our strategy is trying to get them to agree on the revenue multiplier first, and then in terms of the multipliers, like for the valuation, our bottom line is around like 6x because it's like pretty attractive thing. So we're willing to give them like 8.5x. And also like at the very end of the day, we are using this investment to fund our R&D costs, and we estimate the next 3-5 years where we need for like all the costs incurred for our business, and also we need to put in the R&D, and that's around like 40 to 50 million, which is more than enough from this valuation part. And also like in terms of the earn out, I kind of anticipate that, but like we really want the cash up front. That's why like we did not like bring up like those kind of earn out or escrow share structure. Yeah, I think maybe like one thing I feel like can be better is when he mentioned like the earn out, I did not like state very clear, like I don't understand the structure. Like my purpose is to not having two things that's kind of reducing their risk, and then they saw like I thought this earn out would be going to the escrow account, which is not. Yeah, and I think Andrew did like a really good job in coming up with a lot of like creative things in the identification and the reverse termination fee and termination fee to make sure we are.
And just to quickly circle back to the purchase price piece, in addition to the different valuations that Ron used to justify the price point for the company, we also gave thought to what would the clients actually need for TeleTogether to kind of thrive. And Ron interpreted that as like the next 3 to 5 years of R&D, cost of goods, and the expenses that the company would accrue. So we did have a bottom line number of around 50 to 60 mil. So when the initial offers came out, like well above that, I guess that gave us like confidence that we could work on the upper end of our tolerance for the other terms. And also going to the indemnification piece, here I thought the key for us was to show that the litigation risk was low. And if we could show that the litigation risk was low, then we could show that the escrow account would be in excess. And if we could show that the escrow account was in excess, then we could sort of draw a comparison to giving out the excess escrow account to shareholders as sort of a premature dividend, which is not appropriate for an early stage company. And we framed it, and I think the strength of that framing was it kind of puts this issue in like a mutual interest context, because at that point, both TeleTogether and Zoom are looking for the best ways to use their funds. I think one thing that definitely could have been better, or the downside of that approach, was trying to get them to see eye to eye on the litigation risk. I felt like that was something that I struggled with, trying to convince them that actually, this litigation is not materially adverse. And we tried to do the workaround by providing a warranty or representation as a way to still insulate them from that risk, but then have those funds available to them in the form of damages, but only when it's necessary, not upfront and not just giving it out as an unnecessary dividend. But yeah, I think the main weakness to that strategy was just trying to see eye to eye on the litigation risk.
Yeah, also like adding to that in terms of indemnification and termination rate, we are trying to add value for both of the parties. I think a lot of our statements are based on like having a low amount in escrow account is good for both of the party, and also have the termination rate low is good for both of the party. Yeah, I think that's our strategy.
Yeah, for termination fee, I think with more time, we would have pushed for a higher termination fee for Vroom. But the priority for us when we're thinking about what the client wants.
Sorry to interrupt, Mr. Park, but I think that's your 5 minutes according to my time, so we're going to have to stop the post-negotiation analysis there. Hold your applause, please, until we have both teams in the room. Judges, please go ahead and begin your scoring now. We'll collect those ballots from you in just a moment. We will total the score for you, but if you could score the categories, that would be very helpful before we collect your ballots. All right, both teams are now in the room, so I think there's no reason we can't go ahead and give them a hearty congratulations for all of their hard work, not just today, but getting through the preliminary and semifinal rounds. So congratulations to all of you. And thank you to those of you who participated in this year's competition and came to watch the final round. We're excited to have you with us. Our judges are going to complete their ballots, and then we plan to announce the tournament champions in just a couple of minutes. I see we are still just running right on time, which I love to see. So thank you, everyone, for helping us make that happen, despite a slightly later start today than we had planned. We will announce a winner very shortly, so stay tuned. All right, folks, if I could get your attention for just a couple of minutes. While our scores are being tallied and our champions are being determined, we're going to have about 5 minutes of oral feedback from our panel of judges today. I'm going to briefly introduce them and then let them do the talking. I'll start from left to right here. We're honored to be joined by Professor Neil Wertlieb, who works here at Berkeley in addition to having his own private practice, as well as Maryam Naghavi, who joined us today. She has her own private practice as well. And Professor Clint Waasted, who both teaches at the University of, I'm going to mess this up now. UCSF Law, and is also the head coach of our ADR team and founder and chair of the EMI Foundation. They're going to go ahead and give feedback to our finalists in just a moment. But first, round of applause for all of our judges for being here today. Thanks.
To speak. First of all, I want to say I think this whole competition, it was wonderful. It's well designed. The issues are really interesting, and I think both teams here did an incredible job. You collaborated well with your teammates. You were respectful. You came to a deal. You were creative in the different approaches. So I think you both, on both sides, you both did an awesome job here. So thank you.
So I actually want to detail that. You did a really good job in terms of being on top of the issues and teamwork, collaborating with each other, collaborating with the other side. I would say, and this is probably something that you will gain through experience and practice of the actual negotiation in life, I would have, given that one of you is a business student and one of you is a law student, I think I would have appreciated it more if the lawyer was actually the lawyer and focusing on the legal points, and then the business person and then the lawyer would be like, okay, so what do you think? To kind of use each other as the good guy, bad guy, if you will, and not necessarily, kind of all focus on the legal part, but really focus on the business part. I would also say, when I personally go to negotiations, I always put aside all the numbers and everything that is on this page and say, okay, what is the dollar that I'm talking about? How much am I giving to this person and what am I getting, right? If you can get that right on a piece of paper, then everything else is just an ancillary to that. So that's the way I think about it when I go into negotiation. And I think both teams did a really good job when you came back with your package and you talked about the package. But I want you, going forward, whenever you go into a negotiation, really think about it as not a package of numbers and what is on the page, but really the dollar. Because, in any business deal, it's just a dollar. You're giving a dollar, you're getting something for that. What are you giving this dollar for, and what are you getting for? Is it worth it? Is it not worth it? If it's not worth it, why are you accepting it? Are you getting something else somewhere else? So I would have loved to see that a little bit more. I would finish with by saying this as well. I think both of the ladies did a really fantastic job, and believe me, I was the first person to be blamed for this when I started my practice. I would have wanted a little bit of more assertiveness. It's good that all the four of you are very collaborative and want to talk to the other side and recognize their points of concern. But you don't have to necessarily say, I totally agree with you. And this is not just the ladies, by the way. You don't have to say, I totally agree with you. I completely understand. Because if you, my friend, completely understand or totally agree with the other side, then why are we here for, right? So you can say, I hear you. I understand why you may have this concern. I appreciate you explaining your concern. But let me rephrase it so I understand, and let me see if I can convince you why this cannot be a concern, specifically when you're talking about points that, is a matter of perception, like this litigation, right? So those were the overall points that we had.
Okay, well done to everybody. I think everybody being very professional and organized and everything is how you get here. So everybody did a great job there, and it makes our decision much harder. So I want to talk, because I'm focused on teaching negotiation, which I do here and other places, I want to talk about things that everyone can do better to improve on negotiation strategy from that standpoint. And one of the things that I think happens sometimes in these competitions, which was a little bit present here, was an overemphasis on conversation management versus approaching a negotiation from a strategic standpoint. So I want to give a couple of examples of what I mean there, because I think this would be something that you could take forward in a future negotiation. Doing all of the things that we did to set up the board and provide kind of a way to record our discussion is absolutely necessary, right? But we can imagine that thinking about taking that practice forward is easy. We think about it, we do it, right? So we spent an awful lot of our real estate at the front doing that. And what might have been more useful for everyone is to think about some of the things that you know that you're going to do in the future and say some things in the beginning to set up these future moves that you're going to do. And I have two specific examples that are kind of coming here, right? Which is number one, we knew which 4 topics we were going to talk about. So writing on the board is useful, but it wasn't that illuminating, right? And then I would say second is that we can predict to some extent, each of us are going to anchor at a certain level on each of the topics. So when I'm looking at Vroom, for example, and and this is my advice to you on this specific point, you probably knew they were going to come in with a high multiplier, and you already knew, like, look, we're not going to take a high multiplier, and here's why. So I might start the conversation with saying, look, as we think about where we might end up, these are the things that are going to be important to us, right? That the reason that I'm going to reject the offer you're about to make in a few minutes about this high multiplier is we want certainty. We want to make sure that the marketplace is addressing the current status of the market, et cetera. And I'm setting that up ahead of time in anticipation from what comes on the table, and I'm not surprised about it, right? I would say the same thing for TeleTogether. A really interesting strategy that I thought was pretty good, and I anticipated your explanation, but I thought it was a good explanation for why you kind of gave in on exclusivity right away, right? You're just like, well, look, if we anticipate that this is where this needs to go, it can be efficient. But if I want to think about setting up the conversation strategically, I emphasize this point of this is really important to us. It's a concession, and in order to make this concession, we're going to expect these certain things in exchange in a very broad sense, and let's go ahead and proceed that way, right? And so that way, when they come out and make their initial anchor points, it's a little bit harder. They've already heard once that they don't want the numbers to be in this category, and you set that up, and now when they put it out there, it's strike one, and you can refer back to it, and get some kind of traction that way. So there's all kinds of little opportunities all over the place there. I would say the second one would be when we're making offers. A lot of emphasis from both sides about the reasons why we don't want to do something, but not a lot of pivot to here's why the thing we are asking for makes sense in the broader face of the deal, right?
Thank you so much, Professor Waasted. I wish we could hear more feedback, but I know we're a couple minutes over already, so I want to make sure and respect everyone's time. Judges, if you have extra time to give feedback after, please feel free to stick around. Folks, we are ready to announce the champions of this year's tournament. We've got some hardware to hand out to all of our finalists. Without further ado, but I'm going to want an applause for everybody. This year's winners are Team TeleTogether. Please give them a round of applause. And a round of applause for Team Vroom as well. It was incredibly close, you guys, incredibly close. With that, we're going to go ahead and wrap up today's event. Thank you so much all for being here today and for staying until the event's conclusion. I know our finalists and judges really appreciate it. I certainly do. Have a wonderful rest of your day and your week. And we hope to see you at another competition soon. Take care.